and talk.
I'm doing a Coke commercial. Hey, everybody, Chuck Cook here, Aaron Hall from Impact Litigation. I better put our brand up here. This is our brand right here. How do you like that? It's pretty good. So grateful, everybody, for coming today. We wanted to walk through first some of the K cases. I really want to go right to K1 Manila because it's the oldest case. It's the one that's been pending the longest, Aaron. And are you frustrated? Because I'm frustrated.
I'm frustrated with these motions to dismiss.
So the Ramirez motion to dismiss was fully briefed by July 16th, 2021. And that's 3 months next week, or 3 months on Saturday. Now, is that unusual? Not really. I mean, the Kinsley case was longer than 3 months. In Seattle, they sat on that case forever. I mean, Milligan, he sat on for 7 months, 6 or 7 months. So it's not unusual. It's just frustrating because we really kind of can't move forward until this motion to dismiss is denied. And then we can move forward on, holding them accountable. But we're kind of stuck at this place. And then it's complicated by the fact that the consulate in Manila sucks. I'm sorry, if you're listening from the consulate in Manila, shame on you. Shame on you. I mean, there's no legitimate excuse at this point that to be taking these people's lives like this. This is outrageous. I mean, other than, here, we do have one idea. Right, Aaron? I mean, if you have, in any of these cases, but if you've gotten your visa, make sure you update the database, because what we're going to do is we're going to file a notice of dismissal of those individuals who got visas. This brings the case back up in front of the judge on his electronic data sheet. Like, what's going on with that case? Oh, wait a second, I haven't ruled in 3 months. Oh, what's going on? Other thing you probably should realize, just logistically, the court gets new clerks every year. And those clerks start usually like September, right, Aaron, if I'm not mistaken?
Right, yeah.
It's late August, early September. So, but they're gone in July. So these 3 cases we're going to talk about, all the MTDs got terminated in July when the court was I think they're basically kind of without a clerk, or they're getting a new clerk and they're getting them trained. So I think that's part of the problem too, is that the courts themselves may have been in the middle of a clerk shift. Clerks do most of the writing for judges. The judges don't sit and write their stuff by themselves. They have drafts done by clerks. So if you wouldn't mind, if you're a K1 Manila or any of these K1 cases, you don't need to email us. Just go online and update the fact when you got the visa and when you entered. We know some of you got visas because you kind of emailed or reached out, and Lily will be tracking it. Lily's not joining us today because I think she's on vacation. I think a lot of people are on vacation this week. Greg is a little late. Greg is actually speaking at a litigation seminar in Vegas. I spoke earlier today at that seminar for immigration lawyers. Greg just happened to have the late session on ethics that he was speaking on with our friend Cyrus Mehta. So he'll join us about 6:15 or 6:20. But if you would go on and would just update it, what the strategy is, let's get it back in front of the judge. And the only way to do, we can't call them. That's the next part of communication. And so what we'll do is just file a notice of dismissal for those that have visas. We've done this in the Brazil case, right at the very time the government filed their last brief. So that's K1 Manila. K1 Moscow. Now K1 Moscow is the last briefing in that was filed August 17th. So that's been it's a little under 2 months. The consulate is now back up to 5 consular officers, is what I understand. And I know a number of plaintiffs have been able to go to different consulates. Some of you can't. I get that, because you have no money to do that. I get that. So you clearly need to be adjudicated there, and we continue to push for that. So we'll see. I mean, no promises now as far as them opening, but at least they got a few more consular officers. And when we prevail on the motion to dismiss, I mean, they're going to have to adjudicate the cases, and the easiest way to get rid of the case is to adjudicate them. So this motion to dismiss is just a delay tactic by the government, and we will overcome that. So that's been fully briefed as of August 17th. So that's K1 Moscow. It was the smallest group of people, and we know a number have gotten it. But again, please go online and update on the database that you've gotten your visa, when you got your visa, and preferably when you entered the United States. Next K1 is the Rio K1. That's the Penn case, and that was fully briefed August 20th, which was the day we also dismissed a bunch of plaintiffs that had gotten their visas. Again, fully briefed for almost 2 months, waiting on the judge in that case. We want to update the judge. We know they're issuing visas. We know some people have gotten them. So if you would update the database, we'll go ahead and prepare this week. If you can get us that information by Tuesday, Wednesday, and we'll send an email out. We'll, hopefully get somebody at Greg's office and do an email. I think they're all on vacation. Out to the plaintiffs, hey, please update us if you've got the visa so that we can dismiss you from the complaint and push a decision forward. So that's kind of the K1 for Rio and Penn. Anyone to add on that, Aaron?
Nope, you got it. I mean, I'm with you. I'm frustrated that we don't have a decision. I'm not shocked that we don't have a decision, but that's when we need to really move things along. And I like the idea of kind of bumping it to the top of the court's radar with some kind of perfunctory filings. And
my understanding is almost, at least the last time we talked to Lily, who's kind of tracking the individuals in this case, that most people had their files were actually either in transit or at the consulate. Mm-hmm. It was very few that were still at the NVC, but that's been a little bit, and so we need to get that update. We'll have that next week when Lily's back among us. And then finally, the King case. Now, she did tell me about the King case last week that half the people have gotten their visas, or at least at the consulate with appointments. And I think the other half, except for maybe a couple, were on their way to the consulate. So London has been trying to push it out. But London, as I understand it, Aaron, is still working 50% of the time. So literally you work Monday, Tuesday, Wednesday, 1 week, Tuesday, Thursday, the next. I mean, I need a job like that. That'd be a great job. You get paid full time and only work half time, and that's awesome. But I don't get it. London's open. By the way, I heard it's a great time to go to London because literally nobody's there. So the summer of love, nobody's there. Go over and have a good time. So that's our one London.
I don't understand because maybe some of our plaintiffs on the call are like me and they follow soccer. But I watch soccer in London every weekend, and the stadiums are full. It's not
completely full, right? There's nobody's got a mask on.
You got 70,000 people in these stadiums. I mean, what's going on?
You can't put 100 people on the consulate. I just don't get it. I mean, I do get it. This is intentional. It's all intentional. It's all intentional by the Department of State, who has not changed their policies, near as I can tell, at all since Trump was president. Blinken has put no effort into consular processing, no attention paid to consular processing. The new head of consular affairs has done no policy changes that I can see. I mean, have you heard any? I haven't heard any, Aaron. Nothing. It's really unbelievable, considering that immigration was a big issue for a lot of people that got Biden elected in a lot of parts of the United States, and the fact that they either are incompetent, which I don't believe, or in fact just don't care enough to do anything about it. And the thing is, they don't need legislation. They don't need Congress to fix this stuff. This is all stuff they can fix by fiat, by policy, a memo. And there is Mr. Siskin, live from Las Vegas. Woohoo! Greg, you're looking good. I hope your panel went well.
I think it went okay.
But you're speaking with one of the great legal minds of all time, Cyrus Mehta, so it can't be all that bad.
No, Cyrus always makes everybody look good.
Yeah, it's just excellent. So you're in the casino, but not in the casino. It's like you're still in a meeting room, so welcome. When I spoke earlier today, the woman that was coordinating our stuff was actually in the casino. And so there's ringing and noise. I'm thinking, I hope the conference room isn't like that. So I'm glad you're there. We were just finishing up all our K1s, Greg, asking people to update the database of when they got their visa and when they entered the United States, because we want to dismiss them.
Right.
A tactic to try to get the court to pay attention to the case. Hey, dismissing 50 people, 10 people, 5 people, the case is still here. We can even sit in there. despite the pending decision from the court, the following plaintiffs are being dismissed because they have their visas.
And we were saying, the people who have their visas are probably the least likely to be watching us on this video. So we'll send an email as well.
We'll send an email out. If you get to talk to your folks, we'll send an email out tomorrow to these folks just to please update the database so we got that. So that is, in summary, the 4 K1 cases that we have, when the dates were filed, when we're waiting on. And, from anywhere from 2 to 3 months, we're sitting here waiting on actually, King has only been a month. King was 9/2. So, it's only been less than a month. And actually, that's well within the normal. That's completely normal. I want to talk about EB5 Fong. Last Monday night, Judge Mehta denied the preliminary injunction because it was moot, because the EB5 program doesn't exist. Judge Mehta just got to it, I guess, which is weird because he hasn't gotten to the Gomez case, which we desperately needed an answer on, but not in Fong. So what the judge did is he set a hearing on Monday, October 5th, October 20th. I'm sorry, it's not Monday. October 20th. No, wait, hold on. I think it's October 17th. Let me look at my notes here.
The 17th is a Sunday.
I think it's the 20th. I'll double check. We'll let Fong, the plaintiffs, know, and he wants to have a hearing about what's going to happen with the case. The reality is there's no program, and because everybody's at a consulate, and the Department of State's not dismissing your cases, they're holding them in abeyance so they can be adjudicated when the program comes back. It's just that we don't know when the program's going to come back. This is the longest. Well, is this the longest it's been out, Greg, or wasn't it a few years ago? November it came back. I forget.
It's never been out this long. It's been pretty fast usually when it's expired.
It's been out since July. So this is.
Chuck, I'm sure people are going to be asking the question, like, if it gets extended next week, what does that mean? Does do we need to? Would the case be refiled, or would they basically be on their own? What would be
the case is still pending. So if it gets reinstated next week, we would refile the preliminary injunction because it wasn't denied on the merits. It was denied because there's no program.
Right.
All right. So as long as and we're going to ask the judge, rather than dismissing it as moot, we know this program's coming back. And, Judge Mehta, I can tell you what he's going to say. Well, Mr. Cook, I understand the logic of what you're saying, but legally speaking, there literally is no program in which your client's qualified immigrant. So there literally is no legal case at this point. So sorry, I think he's going to dismiss the case. So but as soon as it comes back, we'll talk to our plaintiffs and we'll get this stuff going again. So we're just stuck in this limbo land where we can't do anything. We're just stuck in this limbo land. So that's EB5 Fong, and we have communicated with you by email in Mandarin so that you know. All right. The next thing I want to talk about is the K1 Cairo and the family-based Cairo. So we learned today on our family-based Cairo that we only have 2 plaintiffs left. Both been interviewed. One has responded to a set of documents, and the other one we don't know about. So we'll be reaching out to you tomorrow, find out what's going on. But basically, the purpose of that lawsuit's been done. You got interviewed. That was really the key. Now, we have been asked by the court to say what's the status of this case. So we do have to respond, shorter rather than later. So we've already heard from one of the plaintiffs. The other one we'll reach out to, and hopefully, we can get this dismissed and done because everybody's going to hopefully get their visas. On the K1, we're going to be following up with the K1s, and you can, of course, update the database as well. And we know that all the K1s were shipped to the consulate. We just don't know whether everybody been interviewed. So if you wouldn't mind updating us on that, that would be great. Thank you on that. So that's kind of our K1 there. I want to talk about the Gomez case, the Gomez DB 2020. We know that that's Judge Mehta. Aaron, I would like to file, I'll call you after we're done, but we're going to probably file one little supplemental request to Judge Mehta to clarify his order on the visa entry of people, because he clearly did not understand the visa issuance, because the Department of State now has formally declared that if you have an expired DV 2020, but it wasn't issued in September, you can't come in. And I don't think he understood that. I really don't. So we're going to ask him to clarify that. So maybe we can get that into him tomorrow. That'll make him happy. Send Judge Manus some more DV 2020 stuff. But other than that, there's nothing. We have nothing. On the DV 2021, just briefly, we are waiting to see what's going to happen. This is a very weird case. Aaron, do you want to kind of give a summary of the email that's going out to folks?
Yeah, I can. I don't have the numbers in front of me, but I can tell you that I can pull them up in a second. But basically, we have 480. Let me pull them up. I don't want to get the wrong. I don't want to give
everybody the right numbers here.
Can I make a quick comment on that regarding communications with us? So we've been having plaintiffs, everybody's trying to figure out what's happening, but some people are sending us suggestions on how people should be prioritized this and the other as far as who should get them or how we can't actually take a position on how these numbers should be distributed if it's going to potentially put one person at a better position than another person as far as the plaintiffs go. So please do not ask us, because we can't, even if we wanted to, it's ethically, we're not allowed to take positions that would help some plaintiffs and not help other plaintiffs in that situation, unless we had, basically everybody voting unanimously that to do it a certain way, which is obviously not going to happen. We can take positions that help everybody, so we will, but we will not be entertaining some of the ideas that people have sent us on how telling the government that the numbers should be split up this way or that way. We're just not allowed to do that.
Yeah.
Aaron, did you find your email?
Got it. So we got, I want to just give an overview.
And Aaron, this is important because people don't have the right information.
Yeah.
That's listen carefully. This is really, really important.
All right. So this is a breakdown of some numbers that we've been crunching. And this will all be coming by email if it's not already in your box. So there are 414 GO plaintiffs who had, and that includes derivatives, who had visas issued prior to September 30th. As everybody knows, the court reserved 481 visas to be issued to plaintiffs. We have 607 remaining plaintiffs who haven't had visas issued, and they represent 1,458 people, including their derivative beneficiaries. We're getting a lot of emails saying, hey, wait a minute, the math doesn't add up. We started with 900, what happened? Well, after the amended complaint, a number of people have been dismissed from this lawsuit. And so the accurate information is with us and with the government lawyers and with the court. And anybody who is wanting to claim a GO visa is going to be cross-checked with that information. So please don't be sending us dozens of emails about who you think should not be getting one, who isn't a legitimate plaintiff. People have been dismissed, and that's what you need to know. Let's see. Of the 1,458 remaining people, about 246 were previously given notice that they were documentarily qualified, but they haven't had a visa issued. So do that math. There's 481 visas sitting out there to be issued, and only 246 people have been told that they were documentarily qualified. So people often write us and say, is it hopeless if I haven't been told I was documentarily qualified? No, it's not. There are going to be visas issued to people who were not yet notified that they were documentarily qualified. Let's see. We have a regional breakdown.
I should say, even people that are documentarily qualified get denied for one reason or another at the end. So it doesn't necessarily mean that everybody that was documentarily qualified, even if they got interviewed, would get the visa.
True, and we don't know that all those people will be the first to be interviewed.
I mean, I'll give you one quick example, just so you know, on here. We didn't go and look back at the underlying qualifications for the person for the DV program, and it just so happens that one person recently got interviewed, and as it turns out that they didn't meet the education or experience requirements that are necessary for that. It's not something that we're checking. Frankly, it's not the issue we were litigating. We were just litigating to get these cases moving on there. But that's a visa that gets back, added back to the pile in there. So, and that happens more than you would think.
Absolutely. All right, so the regional breakdown. Again, these numbers include derivatives. So these are people who are plaintiffs and their derivatives who have not yet had visas issued. Asia, 183. Europe, 929. Oceania, 3. Africa, 339. South America, 4. So that's what it looks like broken down by region. As we'll tell you in the email, we're not planning on giving out granular or individualized data. And like Greg said, we are not advocating for them to be distributed in one way or another way. We will advocate that they be distributed promptly, and that's all we can do.
I put up this regional breakdown because this is actually kind of important. It's important because of the Judge Chutkin's decision in the Rye case, in which she reserved 919 or some 900 number just for Europe. That isn't, again, she didn't reserve them for plaintiffs. So you have to understand that if you're in Europe and you're one of our plaintiffs, you also have the possibility of getting one of those visas. So, I mean, Europe has a higher chance. And when you look at what we only had, I think, Aaron, if you recall, 12 South American plaintiffs or something like that. 8 got them and 4 didn't. And we have communicated to immigration, just so you know. We have communicated to the counsel for the government, and I talked to him, and I said, what are you guys going to do? And the answer is, I don't know. I will ask my client. We are considering our options. That literally is the statement. All right, that's what we know. Now, the government has 30 days to file an appeal. 30 days is October 30th. So they can file appeal on October 30th. They could file no appeal on October 30th. They filed no, and they could also begin issuing visas today. Unlike the Gomez case, they have an order to issue the visas this fiscal year. As we said earlier, they could issue them all next September if they wanted to. They don't have no order to do this. They're also under no order about how those visas are to be distributed.
But you do raise a good point here, Chuck, about an issue that benefits all of our plaintiffs, which is the timing of when these visas are actually being issued on there. We don't have to pick and choose, which plaintiffs are benefiting from this, but we can, it's to everybody who eventually gets chosen to be adjudicated as quickly as possible. So that's an example of something that we have, that there's no ethical conundrum for us as far as advocating for as speedy adjudication as possible versus, how they choose which people to actually get the interviews.
Right. So a question that I know that will be coming up in the comments because I get it on nearly daily. What are you guys, I'll put this to you, Chuck and Greg, what are your thoughts about us appealing the order? Why aren't we already committed to appealing?
Well, first we won the case, so let's be clear. We won the case. We didn't get all the visas we asked for.
Well, you could lose it. You could lose everything.
You could be gone, so that nobody gets.
That's the problem. Is that if you appeal, it could be those 481 are lost.
Yeah. Now, should the government appeal, we then have to consider our option to cross appeal. But filing an appeal puts those winners at a substantial risk. Now, I do believe we win an appeal. All right, I do believe we win an appeal, but I can't be certain. And you don't know what judge you get. You don't know what panel you get. We could get 3 Trump judges, and they would say, "You're out of here. Have a nice life." And so, I personally don't think it's worth the risk to just have us appeal. But should the government appeal, that changes the dynamics. But we don't know that. We don't know what they're going to do. They might not want to take the risk either. They might get 3 Obama judges, and they don't want to take that risk. The other question that I see a lot is, well, why don't the government just allot more visas? They don't think they legally can. So I see 0 chance of them saying, you know what? I know you said 41, but we're going to go for the whole shebang. I just don't see that happening. Now, the other concern is legitimate, but this is where it gets into the issue of conflicts for us is, Well, you've got 989 Europeans. Does that mean that if you do the percentages that they get most of the 41? I don't know. That is not something that we can participate in, and it's entirely up to the government anyway, as far as how they allocate these visas. If they do it proportionally, they look at the overall numbers, they do them proportionally. I don't know what happens at that point.
And I mean, to be honest, I think once they, have to deal with the reality of however many they have to adjudicate, I don't think necessarily they're like trying to. I mean, I think they have an incentive to try and do it fairly and in compliance with the procedures as well. They're not necessarily doing taking decisions and how they do that would be any different than if we as three random immigration lawyers were trying to come up with a fair system. It may not be any different than what the government comes up with.
Now, the other concern, of course, there are still consulates that are essentially closed where we have winners. Even though there's no reason to be closed, they're closed. So are you negatively impacted by how state decides to issue it? And obviously a longer delay during the year is helpful to those whose consulates may open later on. So again, I don't know. We just don't have the answers, and we will keep telling you we don't have the answers at this point.
Right, but even on that, Chuck, we have to be careful in terms of saying that a closed consulate that that these cases should all be adjudicated, another one, and all that, without necessarily taking a position that potentially puts those people at a better spot than everybody else. So we just have to be I guess it's appropriate for DV 2021. We have to be Switzerland. As far as
you can tell, Greg spoke today on ethics and litigation.
That was my paddle.
So on the appeal issue, Chuck, like you said, talked to government counsel last week. We will keep those lines of communication open because they're not going to hide the ball. If they're going to appeal, they'll tell us, and then we will talk and likely consider preparing a cross appeal.
If they wait to the last minute to appeal, we can still appeal it. I mean, it's not like we can't get that done in 5 seconds. It's just a piece of paper, but that's kind of where we are with that. I do want to tell people that worry about the H1B wage rule case that we have filed some additional documents there, and that litigation. I don't think the wage rule, certainly as it's written, is not going to be the law, but the Department of Labor is coming back with a wage rule. What we're trying to make them do is do it in a sensible fashion that makes sense. So we just want to let you know that's out there. Now, I do want to address the H1B lottery abuse case that we're waiting on a decision on the motion to dismiss. That was fully briefed as of 10/1, so only been 10 days. I don't expect a decision this month. I assume next month. We've got time. I mean, the reality is the litigation there is to end the lottery in its current format. And so I believe we'll be successful in the motion to dismiss. If not, we'll have a talk about how we're going to deal with this. But this is a fight we want to have. We want to have with our clients, and we will keep fighting. I think the lottery, as it's currently done, is wrong. I think it's morally wrong, and I think it's legally wrong. So we will keep fighting on that, and we'll keep you apprised. But as of right now, there's nothing going on other than waiting for a court decision on that. And then our last piece is, of course, the 900-pound gorilla in the room, the USCIS AOS EAD Delay litigation. By the way, so you guys know, I did a 2.5-hour Zoom call with all of our plaintiffs. I got done at 7:30 or 7 o'clock on Thursday night or Wednesday night, whatever that was. I forget when that was. But I thought we answered questions from everybody. And I know we have questions here today that will come up. But, here's the thing we asked you to do. We asked you as soon as you possibly could, but no later than Wednesday this week, to get us a decision on what you want to do. You each got an email about the options. The first option was just to dismiss your case. The second was to dismiss it and then pursue individual litigation. And Aaron, what was the third option?
Well, some people might have local counsel that they want to
transfer. Local counsel take your case. So we could pursue your case, or you could have your own local counsel pursue your case. So we have had a number of people dismiss their cases. We filed motion to dismiss, particularly on those that got their visas. Some people got their green cards, and at least a couple have gotten their green cards since October 1st, because the government didn't stop working on it. It's not the DV lottery, so they're still working on the cases. The concern at this point is, and I'll just repeat this briefly, and we'll answer some questions about this a little bit later, but the preliminary injunction was focused on preserving visas. That was the focus of the preliminary injunction, and getting visas adjudicated before the end of the year. That issue is gone. The preliminary injunction will be denied. There is zero chance that anywhere that any judge will grant, in my opinion. Aaron, do you disagree?
Nope.
Zero chance. It has to be. Now, the complaint itself was both an effort to get the visas reserved and a mandamus. Okay, it was a group mandamus, really individual mandamus, and everybody's got a little paragraph in the complaint. But the pending motion is not going to help you at all. And your case is, is either sent to the district in which you live because your case is physically there, or it's at a service center or the National Benefits Center, where they could also adjudicate cases, although, as we noted in the call, immigration has never, they have under Biden not revoked the policy to interview everybody. They may not be interviewing everybody, but they haven't revoked the policy. So the question is, and of course it's unfair if you're in Nebraska versus Texas. Texas is taking 10 months longer to do this, then completely outrageous. So personally, I think the best option would be to dismiss the case and refile either where you live or at a service center if you want to do that, either Nebraska or Texas, and go from there. Now, 10 of the plaintiffs already have been dismissed by a judge in Nebraska. He just dismissed them without a hearing, and boom, dismissed the cases as moot, even though they're not moot, but he did anyway. That gives you a chance to refile the case. But you would want, as I explained in the call, you would want your own complaint detailing at length, rather than just the short declaration you did, a little paragraph you had, detailing at length the hardship you're suffering because USCIS is not doing their job in an efficient manner and not obeying the law. So let's you guys have anything to add on that? And I answered the question over and over and over again, but people had good questions, and it was good to talk to people. People were very calm, very nice about the whole process.
Yeah, I mean, I could tell you at this conference that this litigation conference that I just got done speaking at, that this case has come up probably on every panel of the day so far. It's one that I think that the immigration bar is really worried about this judge and what happened on there. So I don't think the issue is dead as far as the issue, hopefully being dealt with. But I think as far as Chakrabarty goes, the options are where Chuck just discussed. The only other thing I would probably add is that, we get these questions a lot. Is it better to sue individually, or is it better to sue as a group? And there are some advantages to suing individually, and Chuck just outlined it, which one is you can outline a lot more of your harm facts and get more attention by the judge of your particular situation. If you have a weaker case, it's probably better to sue in a group. But if you have a really strong case as far as the hardship you're going to suffer, that helps there. The other thing that we see more often in individual cases is a willingness on the government to settle by approving a case. They're less likely to do it on a mass case, or they will moot out plaintiffs where they can. But on an individual case, it's been my experience, we probably have the odds are better that we're going to reach a settlement quickly on an individually filed case versus a mass case.
So a couple of points on that. So we had, I think, just one case, although I might be mistaken, that got transferred to the Western District of North Carolina.
Yes.
And in that case, I called the U.S. attorney up, and I just open-ended, wanted to talk about the case. And since it was an individual case, like Greg was saying, he just said, let me get back to you. Within 24 hours, he says, I think this is going to resolve really quickly. And he's been in contact with the agency. He got the RFE they need, and he said, as soon as they get this stuff in, I think everything's going to go away. And so that's kind of the difference you can get sometimes with an individual case as opposed to a mass case. Now, why do we file them as mass cases in the first place? Well, most of our mass mandamus cases have not only kind of an unreasonable delay, but some also common fact or question of law that ties all these people together, that ties their claims together. Yeah, exactly. And that's because, usually mandamus cases or unreasonable delay cases are very individualized, very fact specific. So you really usually need some common fact or some common unlawful policy that you're challenging. The EAD case that we're working on is more just a common delay for everybody than an unlawful policy like a presidential proclamation or something like that. But usually mandamus cases are more individualized, and that's why at this point, now that we don't have the common issue of the reservation of visas that we were seeking to resolve before September 30th. Now we're in and now that they're all severed, we're in a posture where it really only makes sense to me to have these done as individual cases.
All right, so we're going to jump into some questions. And the first one's from Kieran. Kieran actually emailed me through Ryland, and then he asked this question in 5 or 6 different. Let's not have thought, Kieran, we were going to get to your question. And I don't know if we talked the other night. I hope you were on the call and were able to talk to us. And you take one case of a date not current and fight with USA, present the argument how these are allocated for AOS versus H1Bs. I don't know exactly what that means, AOS versus H1Bs.
I think he's talking about
he's talking about our legal theory
interpretation of the language that we had raised.
Oh, okay. Sorry, because it's been a long day.
Yeah.
Well, here's the first problem. The complaint's not individualized for that issue. Okay, we talked about it in the issue, and because, well, take a better set.
Well, I think one of the issues there is that is still the timing question on here, and that's, we could raise that issue in an individual complaint. The problem is right now, I think, which, unless we could, somehow make the argument after October 1st that we still have the right to make that we still have the right to claim it. I think it's kind of a moot point. I think if, for next year, for people that are doing it individually, they could make that argument. And we know from the Mississippi case that you could make that argument on an individual basis, and it succeeded on that individual case.
Kieran, I'm just sitting here thinking about that particular issue, because that would obviously we still need to withdraw the preliminary injunction. Okay, still need to withdraw that. Government has, and keep in mind, the government has a motion to dismiss pending as well. And most judges will just take advantage of that and file a motion to dismiss. And we really can't file an additional motion until that motion to dismiss is decided. Now, should we survive the motion to dismiss, then that case might keep going. The question then becomes, where do you want to litigate that case? And what do you want to litigate? That is clearly a policy case. That is not something resolved in the Atlanta district. It's not something resolved in the Texas Service Center. That is a policy case, which would, again, be appropriate in Maryland, where the policy is made for the agency. It's a great, I'm just thinking out loud, Kieran, because I think it's a really great question.
I think so too. Here's what's going through my head. It's a great issue and it's a great question. One of the reasons it was ripe in the pre-September 30th litigation that we filed in Chakrabarty was because not only did we have a policy or an interpretation that we thought was illegal, we had the harm of the visas disappearing at the end of the year. And that's a requirement for standing to challenge a policy.
Yeah, that's my concern. It's a standing issue because there's no immediate harm right now.
Right.
Immigration will come in. Don't worry, Judge. We're going to take care of all of these this year. We're way better than before. Mm-hmm. And there's no harm. There's no immediate harm. And that harm is kind of the key to defeating the policy. I mean, how we defeated the H1B wage policy. There's an immediate harm. And we just don't have that harm if at this newly into the year.
Last year was unique in the number of visas that were available, right, for EAD cases, and that was disappearing on October 1st.
Yeah, because then it just said we're gonna change our policy and assign them, and then now they're all used.
Well, we have the numbers coming up, rolling over again on October 1st for this month, that we just don't know at this point what that have the information on that. But that's to your point, Chuck. That is the harm later in the fiscal year. We've heard about possibilities for retrogression next month, but we just I don't know what.
Technically, you wouldn't retrogress if you had a number assigned, right? I mean,
Well,
you run out of H1B numbers and you have a number assigned, you can get an H1B, right? But if the number retrogress, you can't be approved. Even if you got a number assigned, well, this is where it gets very confusing as to how we want to.
I mean, I think long and short, it's an interesting discussion to have, and I think we will continue to have the discussion as far as what the options are. But I think it would be a long shot for sure.
Yeah. So Kieran, that's not an answer you're yet, but we will be back in touch shortly. We need to do a little more analysis of that. It's a really good question though, and it just may be something that's better done this next year. And really, because it wasn't the focus of the complaint, the focus was the reservation of the complaint with the argument that they could have done this. They're misinterpreting how this works. So we'll go back and take a look at that and get back with you. Thank you, Kieran. A really good question. Daniel, round 2, Milligan, Manila, edit. Oh, will round 2 Milligan be added to the mandamus?
I think they're asking about whether they'll be added to Ramirez.
Well, we have to get through the motion to dismiss.
We have to survive them. And once we survive the motion to dismiss, I think that's the plan.
Then yes. And again, anybody in any of the K1s, if you've been approved, please let us know. Ruse Bay, everyone, what do you expect the government to be issued for? We already answered that question. We don't know. Chakrabarty, PD is 2013, or it doesn't happen. Is there a good chance for individual mandamuses? Yeah, but there's no individual, because actually, Greg, you sent a really great website around earlier today that you had picked up from plaintiff. This is greencardly.com. Aaron, have you seen this?
I haven't gotten to play around on it yet.
Oh my goodness, this is remarkable. I haven't done a lot on this, but the data on here is fascinating because you've got the receipt dates when they're processing. So you've got the MSC processing AOSs for EBs from September 2020. So right before the filings, but Nebraska is in August of 2020, but Texas is in September 2019. This is really great data on that, and I think strongly supports an individual mandamus. There's lots of great breakout stuff on here at Greencardly. That's greencardly.com. And again, I don't know who does this, but kudos to you. It's great work. Thank you. Mandamus denied referring to Ramirez versus Blinken. Patrick, I know this is earlier on, but there's been no mandamus denial.
No, I think he was talking to the last commenter.
Maybe
Daniel.
Okay.
Yeah. As
non-DQ'd go, we'd like to know their dates, all remain to in their documents. No. We just, that's just not data we're going to release. Thank you, Patrick, for update. I know you asked last time. Oh, and I hope you're enjoying Maine. Eat some lobster for us. My update on the DUS update all I did was say the facts. There's no update. It's just the facts. It's a nothing burger. There we go. Let's see. Patrick thinks we're going to survive. I think so too. Greg, welcome back from your vacation. Yes. Hey, look at that. Look at that. I did not pay this, Rohit, to say this.
This is a plant.
Heck, you got a fun
plant.
Thank you, Rohit. Did you enjoy Hawaii, Greg? I know you were out of touch for a while.
I did. I didn't taunt people with my volcano pictures on Twitter.
Did you ride up or just ride down?
I didn't ride by the volcano, but I did ride the Ironman bike course.
Good for you. That's awesome. I suppose you didn't swim in the waters around Maui for the Ironman swim, did you?
It's a big island, and no, I did a lot of swimming, but it was all pool swimming.
Good for you. Update on the H4 EAD delay case. Greg, do you want to update folks about where we are on that?
Yeah, I mean, I guess. Well, I don't know if can I say
Did you
anything
talk
about
to Jesse today? Did you talk to him today? Or?
I have talked to Jesse. So can we say anything about that?
I think we can.
All right. So one of the reasons why we've been holding off on moving that case is because we have been in discussions about with American Immigration Lawyers Association about co-counseling with us on that case and potentially doing it as a class case, which would help us on, for example, the venue issue that we faced in Chakrabarti. So AOA has given their they've gone through their internal approval process and blessed pursuing that. So we should hopefully be able to move this quickly.
Good. So that's kind of where we are. We're literally going to be doing that. I think.
I think this will be very helpful in terms of our odds in the case.
Yeah, I agree. Rahul Pandey, thank you very much. Here's the problem with recouping wastage. We don't have a legal basis to argue for it, other than government negligence.
It would be right.
Yeah.
It's the right thing to do. It's morally correct.
It's morally correct. It's ethically correct. It's equitably correct. But you'd have to get an extraordinarily bold judge. And then you'd have to survive an appeal. Really hard. But
I mean, we're going to discuss if there's a judge that has been transferred to that we can cherry pick that that might be right, but Chuck's right. This would be really hard.
But for fiscal year 2022, if they are not making progress, we talked about this in the call the other night. If they're not making progress in the first quarter, we'll get first quarter numbers in January. If they don't have a quarter of the 290,000 visas done, I think we sue. I think we go right in. Because remember, one of the kind of, frankly, I thought the jerky argument the government made, why didn't you sue in January? Well, we didn't have any numbers in January. You didn't release them. You didn't release them until May.
We'll also discuss.
You weren't doing your job. But why didn't you sue us earlier that we weren't doing our job? That's what he was saying.
Suing the government on this case is the Goldilocks problem. If you sue early, like we've done in Enunciado, then their arguments are it's too soon, it's premature.
For sure.
You do it a week later, then it's too late. Why didn't they bring this earlier?
That's a great comment.
Yeah, I mean, one of the issues we'll discuss as well is venue, and that's an issue that came up at this conference is potentially suing DHS instead of USCIS and getting it back to DC.
Daniel, again, when we win on the Ramirez case, we're going to add the Milligan plaintiffs to it. So and the judge will add them. I mean, that's not a problem. H1B Lottery Visa waiver in front of the judge. We publish a decision by the end of a potential third lottery would happen in early November. It's a great question. We did talk about that third lottery, and it's in our brief. I don't know. I mean, we can't. The thing is, we can't push a judge. That it doesn't work that way here in the United States. You don't push a judge. They do what they do, and that's unfortunately the nature of the beast. Here's a great question for you, Greg. Any update on immigration reform and the budget reconciliation bill? Plan C. Of course, Plan Chuck.
Yeah. Well, all right. So, I mean, as far as that goes, a couple things I did pick up some intel on potentially outside of reconciliation on an appropriations bill where there's some discussion about doing a visa recapture, which would be potentially something that would help a lot of people if that happens. And that we don't have to worry about reconciliation rules and all that other kind of stuff. Of course, you have to get the Republicans can filibuster that kind of thing as well. But the idea is that hopefully recapture is something that has enough Republicans on board that wouldn't be an issue that they would have too much of an objection. So maybe. As far as budget reconciliation goes, it's not dead on there. There is a Plan C. There are some ideas for that. There's still a possibility that the Democrats could override the parliamentarian. That's not completely clear yet on there. I know.
Thank you said that. And the first thing that came to mind was one of my favorite movies, Monty Python and Holy Grail. I'm not dead yet. Go take a walk.
With that said, I should say also that there are some ideas that haven't been presented to the parliamentarian yet, particularly on the skilled immigrants. On there now. There was this whole worry that some of the Democrats had that that if you presented all these, presented the skilled immigrants and the undocumented folks all together, that they could torpedo one group and not the other, and so they've kind of tried everything out. And I think at this point, if there is a group that may want to present a plan that's just aimed at family, employment, and lottery folks, and doesn't deal with the other issues that they can't get the parliamentarian on board with. So there is still discussions. There's still an attempt. They haven't given up, and we will see. I don't want to get people's hopes up on here. I think sometimes I try and get my own hopes up on these things, but I would. I wouldn't say to write off the whole thing at this point.
I'm the pessimist.
You are the pessimist.
I'm the pessimist. Just FYI, we won the Kinsley case, which was awesome. That was a great win. I don't think they're going to appeal that case.
Have they put up anything yet on travel.state.gov about Kinsley?
Well, they haven't talked on state.gov about how they're going to react to Kinsley, which is do away with the stupid NIE program. Because you know what's going to happen. The travel ban is going to be lifted for Europe November 1, and then
they can still do NIEs. They can still do CBP NIEs. They just can't do
CBP, which is where it should be done always. All right. Let's see. Chase and Will fill inquiry for a case update on K1 Manila and expired our case. They asked for a letter of reinstatement. Yeah, we dealt with this before. They're supposed to be renewing these cases themselves without you asking for reinstatement. That doesn't make any sense. It doesn't make any sense at all. Let's see.
If that does happen, let us know, because we've been able to get the government counsel to fix that issue.
Yeah, I actually spoke to government counsel in Nebraska about this. They're not going to be pushing these cases forward because they're literally sitting on like tens of thousands of cases. So unlike a district office, which can reach in and pull it out and get it done, these are literally tens of thousands of cases, and they're not going to do anything in a group mandamus to come out and try to move these cases. They're just not. Plus, they already, they're sitting on a judgment against 10 of the 74 plaintiffs. So, they're not as motivated as a U.S. attorney in North Carolina or U.S. attorney in Georgia or Florida or Tennessee that all got their cases approved on this. This case, none of these cases is going to the Supreme Court. You can take any case you want to the Supreme Court.
I don't think you want it to go to the Supreme Court.
No, you don't want this Supreme Court, that's for sure. Let's see. Gorky, good to see you. Can I go to deactivate my... Yes, Gorky, if you have a freaking DV 2021 visa...
Get your butt on a plane.
Get your butt on a plane. Get over here. And then you can go back you get a plane the next minute. I don't care. Because the visa, once you enter, is your green card. All right? So, yes, you don't need the plastic green card. Let's see. Wouldn't they be mooting out? You would, this goes to the issue of different U.S. attorneys, different policies. You would think that Urch would say, let's get these cases mooted and be done, but they're not. They're not. Let's see.
Well, they're strategic about what they're mooting. So, it's the workload of any particular U.S. attorney's office that's going to control what they're going to do.
Yeah, and Greg, this goes to your question earlier about Kinsley. We just, they should be doing it. There's an order in Kinsley. And certainly we have 9 plaintiffs that this, because it only affected the plaintiffs, but obviously the meaning is extraordinarily broad. Greg, I know you guys were reaching out to them and seeing what they have interviews scheduled, but I don't know if we have an answer to that yet. I don't think we do. We'll have an answer by next week. So here's a great question from Ash K, because this is something we know. We know that they have adjudicated and approved adjustment cases for later priority dates in the same location that they have earlier priority dates pending. We know that's true. Even though they're all current, we know it's true.
I don't think that USCIS would say that they're supposed to adjudicate by priority date of the underlying petition. I think they would say if they're both current, we adjudicate them in due course after the kind of first in, first out 485.
Yeah, which we know
which is also not true.
Because one of our colleagues on Twitter or on one of our listservs said, hey, I filed an I-140 concurrent 485 3 weeks ago, and I got an approval on the I-140 and I-45 today. 3 weeks. This happened today. A friend of ours in Florida filed this at a service center. So we know that first in, first out is a lie. We know that, and we know it's been a lie forever. A lie.
Right.
Not an
That's what the government argues every case, though, is that if somehow they give you a benefit, it's taking, it's somehow taking you out of a line, even though there is no line.
There is no line because it's completely a lie. Okay. Ranjit, the reason we set the 13th is because the court's going to start dismissing these cases, and it's just better to get the dismissal in yourself without prejudice, because a judge could order it with prejudice. Judges got discretion.
Let me address the second part of this question. The second part of this question is, why can't we just wait for court to dismiss it?
Well, you could, but
but listen, we have to. The attorneys on this call are not admitted in every district.
Right.
We have to get pro hoc vice. We have to get local counsel, and that costs money. So you have to hire us to do it. So it's better to dismiss it, not have to pay those fees, and then refile if you want.
Right. Okay. Kieran, I am convinced we will get your green card, and I that's the great thing about Chuck and Marty. Everybody's going to get their green card. We just wanted to get it now. That's kind of the goal. Any laws to correct the Tier 4 prioritization for DV 2022?
Well, that's what we won on. Well, we won on that issue.
Yeah.
Well, not supposed to be but they're not supposed to be deprioritizing DV, any of them anymore. I mean, they could do it again. I think
they published it. They are.
They are.
Right, but I understand that. But I'm saying is it's a loser for them.
It's a lot of hubris.
It just basically means we are definitely going to be suing again.
Yeah, I mean, I think what we want to do is we're going to give them October. What are they doing? How many people are they interviewing? How are they prioritizing people? Because we have to have a history. You have to be able to have facts to go to a court with. Right. So
I think the answer is, assuming that they haven't changed their behavior, the answer is yes, and we will win on that issue again because they're ridiculous. But
Akshay, who's really all over this call today with questions, would you sue?
Akshay's all over Twitter also.
Without charging a fee.
He's one of my favorite retweets and likes on Twitter. As far as I like, I'm liking his tweets.
So we can't sue for no fee on an EAD delay, but we have the EAD delay state case coming up, so you're welcome to join that. Let's see. There was a decision that MSCs can't use Trump. Yeah, that's the Kinsley case. Yeah, well, that was last week. So the Department of State just takes their own sweet time. And if we have to go back to court on Kinsley because they're not obeying the rules, then we'll go back to court to the judge on that. EB3 is going to retrogress. I don't know what date. I just don't know. As soon as we should know. You know, Greg, remember the old days, the good old days, when by the 11th of the month you would have the visa bulletin? The good old days.
Yeah, I mean, I'd also take a bit with a grain of salt that it's for, what's happening on there, because they've been just wrong in their forecast multiple times about what they're going to be doing. So I don't think Charlie had enough information necessarily to be very exact about it when he made the announcement there was going to be retrogression in November. And I think in a lot of respects, he had to wait and see what the data shows.
Yeah, well, he has to see how many, supposedly immigration was busting their hump to adjudicate all these 485s in September. Well, if they did that, there might not need to be a need to retrogress because they just got 290,000 visas. So why retrogress? Because presumably everybody who was current has filed. There's not going to be any more filings for 485s.
It's possible that their forecast was they were being more conservative than necessary, and that Charlie could be more generous depending on what the numbers show.
Yeah, I mean, there could be that. We'll see. I mean, it's just really just a question of what's going to happen. I do want to show you guys this chart. I want to share the screen for a second here. Let's see if I can do this right screen. I want to share this screen here for a second. This is that website I told you about. Look at that bump. This is the I-140s received. That's you know, that's the snake swallowing a pig right there. You know, consistent filings, and then boom, all at once. Presumably, they got enough visas approved in September that with the new 290,000, because I don't think they have 290,000 visas pending, that means they won't have the retrogress. We won't know that, okay? And then Gorky, you're welcome. Last question. When can we expect response to folks who are selected option 2, interest proceed, and what are next steps? Well, we were waiting till the 13th. We're going to get together on Wednesday, look at everything, because we need to have everybody all at once. We need to figure out what options are available to us and to you, and we'll be doing that, okay? And last question. Do not contact the KCC, please. You will get nothing out of it other than wasted time. There we go. Thank you, everybody, for participating. We'll see you on Impact next Monday. Greg, myself, and Aaron will all be on live this week on our own YouTube channels and our Facebook, and we'll see you then.